if I can just try and tell you procedurally what's going on with Doe. Doe, who has been outed already in lots of newspapers, unfortunately. Mr. Doe, his crime was committed before the registry even came into existence in the state of Maryland, which is 1995, okay? His offense was in the 80s. I think it was 82 or 4, something like that. However, he was not convicted until 2006 because this was one of those recovered memory cases of the victim. And so he pled guilty, was convicted, and made to register under the laws as they existed in 2006. Now, in 2010, October 1, 2010, the law changed, which is what Brenda has been talking about, to make all the new restrictions that they put in place in 2010, which was to increase the amount of time you're on the registry. You all know it went from 10 years to 15, and then 15 to 25, and then lifetime, of course. And it started the whole tier system, tier 1, 2, and 3, because before that, they didn't have a tier system. There were 4 different categories of offenders. So in 2010, when that law was passed, it was made retroactive to anybody and everybody, even those who had been committed their crimes before 1995, before the registry even existed. So we challenged that on behalf of Mr. Doe, saying that that's unconstitutional because there is, and I'm not going to get into all the legal mumbo jumbo, but for you, it just doesn't feel right that they should be able to add punishment to something that was done a long time ago when you've already served your sentence. They can't increase it. They, the legislature, can't do that. That's called an ex post facto law, all right? And that is unconstitutional. And that gets back to what Brenda was saying, why the legislature says it's not punishment registration. Because if they call it punishment, then the ex post facto constitutional provision kicks in, okay, and says you can't do that. So all these years they've been saying we can do it because it's not punishment. Everything we're adding to the restrictions and the burdens is not punishment. And until Doe went to the highest court in the state of Maryland, the court had always agreed that it's not punishment. But finally, in the Doe decision, we got the state's highest court to say, you finally crossed the line, legislature. The restrictions, the burdens, everything that you're making registrants do now is punishment, okay? Which is really was a huge success to get them to say that. Because what that meant was the law that in 2010 that made it retroactive to everybody, even before the registry existed, is now unconstitutional, okay? So, of course, they said Doe has to come off the registry because his offense was committed before 1995, and this new law can't be applied to him. So we were, slapping ourselves on the back. This is a tremendous victory. That lasted for about a day because, you would think that what the state would do is say, all right, we lost. We're going to take Mr. Doe and others like him off the registry. But that was not what they did. So what they did is even crazier than you would imagine. But when the court on appeal reverses a case or rules in somebody's favor, what happens is it has to go back down to the trial court just for the court to sign the order saying reversed. That's all. It's just a matter of signing something. So we went back down to the circuit court in Mr. Doe's case, and I suggested, with the help of Brenda and Larry Neely, an order for the judge to sign, which said, take him off the state registry, NCIC, all federal registries, take him off everything, okay? Anything and everything having to do with the sexual offender database. And the judge signed it. Well, the state filed a motion to alter the judgment, saying you can't do that because you're removing him from the federal databases, from NCIC, and you have no authority to do that. So then that's when I filed a motion to hold the state in contempt. And the judge signed that, saying, you state, tell us why you shouldn't be held in contempt for refusing to take him off the registry. And so what happened is the state appealed. They took him off the registry, and then they appealed the judge's signing of that order. So we are back in the appellate courts on this issue, okay? And the state is arguing this, which I think they're dead wrong, and my paralegal Tom has helped me with this too. They are arguing that, all right, fine, even if Doe has to come off the Maryland registry because of the decision of the Court of Appeals, there still is an obligation under federal law, under the Adam Walsh Act and what's called SORNA, that you must register. So we can't take him off the registry because federal law requires us to keep him on there. They're wrong. They're just flat out wrong as far as I'm concerned. But that is what they are arguing in every case that Doe affects. And the other thing that the state is arguing is Doe only applies to those who are exactly like Doe, which means that your offense occurred before 1995. And I think they're wrong about that as well. So here's where we are with Doe. Doe is now pending in the highest court again. They just took it a week, not even a week ago, a couple days ago. Yeah. And it will be argued. I'll argue it in May. And we will have a decision in that case by the end, at the latest, by the end of August of 2014. So that case, this is the issue in that case in a nutshell is, even if you have to come, if you fall under the Doe decision that it's unconstitutional as applied to you, does the federal law require you nevertheless to register? That's the issue. And that's the last leg the state has to stand on, pretty much. There's no other argument for them to make, at least not, they haven't made any other argument to my knowledge. So let's say that gets resolved in Doe's favor. Let's say I win, okay? Which means that you don't have an independent federal obligation to register, okay, in the state. And you must come off the registry. The option that remains is the state can ask the Supreme Court, the U.S. Supreme Court, to take the case. And I have it on pretty good authority that they're probably going to do that. They're going to take this as far as they can. Now, that doesn't mean the Supreme Court will take the case, because they may not be interested and they can choose not to. So this, if we win that issue, then anybody who is whose offense was committed before 1995 will have to come off the registry. There's just no two ways about it. The question, though, becomes, is the state going to do that automatically and just go through the list and take everybody off, or are you going to have to fight individually again to say, you have to take me off this registry? And honestly, I don't know the answer to that question. My hope is that they'll just do it. Because otherwise I would fight them again and say this is acting in bad faith and we need damages now. We need money from the state because you can't keep doing this, dragging it out. Yes, sir.
I've also heard that.
I'll hold the rest.
It essentially is, does Doe apply to those whose time on the registry was increased as a result of the change in the law in 2010 that made it retroactive, where they came in with the tier system and increased from 10 to 15 years and 15 to 25. Does Doe apply to you? In my opinion, yes, it does apply to you. But remember what I said, the state is, their theory on Doe is that Doe applies only to those whose convictions, or not convictions, offenses were committed before 1995. So that's a fight that we're going to have to undertake. And I'm going to tell you the fight that we will be undertaking. So at present, the whole federal question is pending in the Court of Appeals and will be argued in May. The outcome of that will affect everybody, because the state is arguing that in everybody's case, that, well, look, even if we have to take you off in the Maryland registry, federal law still requires us to keep you on the registry. So if we win that, that's knocked out. That argument is gone for the state. So then the issue becomes, who does Doe apply to? Does Doe only apply to people whose offenses were committed pre-1995? And my legal knowledge tells me no, that if a statute is unconstitutional, it's unconstitutional, period. And you can't just pick and choose who it unconstitutionally affects, okay? At the moment, I have to keep straight along these cases because I have John Doe, John Roe, John Lowe, and I can't remember who's who. But in any event, there are two cases that I have also at this time pending on appeal, that not Doe, two different cases, that where the issue is, does the Doe decision apply to someone under these circumstances? You were convicted after, and you committed the offense after 1995, but the offense was not one that required registration. And then in 2010, when the law was changed and a lot of new offenses were also added to require registration, now you have to register, all right? A lot of those, the one offense that comes to mind right now is misdemeanor possession of child pornography. That was not a registrable offense pre-2010. And in 2010, it was made a registrable offense and threw people onto the registry who had never been on it before. So that issue is pending now on appeal, and that is, does Doe apply to these people, okay? So if you fall in that category of offenders, that will be resolved in this case that's up on appeal, okay? The other category of offenders that I believe that Doe does apply to is those folks who were on the registry already for 10 years, 15 years, and then as of 2010, your time was increased on the registry to 15, 25. Most were increased to life. I mean, a lot of offenders. And it's my understanding that 85% of the registrants in the state of Maryland are in a lifetime category, which is just outrageous, but I mean, that just can't be. But anyway, that issue is not on appeal and is in no case that I'm aware of that's up on appeal right now. However, that is a category of people that FAIR and I are reaching an agreement on to have a class action lawsuit against the state for that discrete category of offenders, those whose time on the registry was increased as of October 1, 2010, when the law changed. And so what that entails is getting plaintiffs who fall in that category who we can bring a lawsuit on behalf of. Now, FAIR will be our client, but the plaintiffs who fall in that category, their names will be on the lawsuit. So one of the things that we need in order to move forward on that are willing participants, willing plaintiffs. And you have to understand that when we're talking about lawsuits, particularly against the state in this area of sex offender registry laws, we need those kinds of plaintiffs who are what I like to say sympathetic, all right? You shouldn't have a huge record that dates back to infancy, because that's not sympathetic. And this would be a jury trial. Maybe it could be a jury trial. We could have a judge or a jury. So we need plaintiffs who are sympathetic, whose time on the registry was increased, preferably, but I'm not limited to that, but preferably somebody that was taken from a 10-year to life, and whose offense was not that, what's the word? I don't know.
Egregious?
Egregious. Something that, somebody's going to read and cringe and say, I can't do something for this person, whether it's right, wrong, or the right thing to do. I just can't do it. Because we're also trying to figure out the right court to go in because, we can pick the jurisdiction. Right now, we're thinking Howard County because there are pretty progressive judges on the bench in Howard County and pretty progressive population, actually, so if there was a jury trial. So that's what we're looking for this lawsuit. Because if we're successful in that lawsuit, then pretty much everybody's been covered. All the classes that we think Doe applies to have been covered either by ongoing appellate litigation right now that could be helpful, and then this class action suit that would be helpful. So, of course, it takes money. It takes money a class action is a huge undertaking, no matter how large the class or small the class. It's a lot of work. My paralegal is shaking his head up and down. Yes, it's a lot of work because we have to go through whoever's the plaintiff, every single one of your cases, and open files on every single plaintiff. You also, if you choose to be a plaintiff, have to know your name's going to be out there. And this will hit the newspapers, there's no doubt, because this will offend a lot of people, might offend a lot of legislators. The Doe decision itself offended several legislators. I mean, my own state senator said it was an abomination, but he's not a lawyer and doesn't know law, so I don't care what he thinks. So what we need are those who are willing to be out front, have your name there, those who are willing to contribute to the class action. And even if you don't want to be a plaintiff, a named plaintiff, we need still you all who are going to be ultimately affected, even if you're not a named plaintiff, to help contribute to the action as well. And Brenda and I were talking, and what can be done is we can set up some mechanism where the funds can be given to the law firm that would go into our escrow, which means we're not going to spend it until we earn it, actually do the work to earn it. But I think it's important, as Brenda said, we are all in this together. So even if you aren't a named plaintiff, a contribution is extremely helpful because you will benefit if we are successful in the lawsuit. So it's extremely important that you folks get involved. And we can certainly set something up where, we can screen folks who want to be involved so that I and my partner and paralegal can look it over and see if we think you would be a good person to have as a named plaintiff. And even if you're not a named plaintiff, I really do urge you to contribute to this because it's the last category, I think, that I can think of folks affected by the Doe decision that can benefit from the Doe decision with a lawsuit. Because the ongoing appellate litigation right now will help people too. But I've been retained for those already, and those are moving forward anyhow. But those do not cover that category that we want in the class action. So I'd be happy to answer any questions. Can we do the questions now, or do we want to?
Yeah, I'll add just one little tidbit.
Yeah.
As far as the money goes, Nancy did mention that that you could contribute directly to the law firm if you're more comfortable with that. And as you say, they'll put it in an escrow account. You know that it's there with the attorney that's going to do the work. You can also contribute to FAIR's legal fund because we'll be putting that money over to them as well. We're looking at thousands. We're looking at probably in the five digits to run a class action like this. And so we need your contributions, large or small, and I did want to mention that. Another thing that Nancy and I talked about just briefly beforehand, so we don't have this all lined up, but one of the things we talked about was even if you're not a plaintiff, if you want to feel like you're a part of it, and you contribute we'll set an amount, I'll say $1,000, just to have a number out there. If you've put in at least $1,000 toward this case, we can treat you like a plaintiff in terms of the reports that you get, the updates that you get. So even if your name isn't out there, you're a stakeholder, and then you'll get the updates that the plaintiffs would also be getting. So, just as call it a bonus, I guess. Everybody will benefit from the class action, whether you've put in $40 or $4,000. But, if you really put forward a little extra effort, we'll put forward an extra effort in terms of getting reports back. So Nancy's agreed with that. We'll get it all firmed up and post it somewhere so you'll know. But I did want to add that in.
I forgot. Thank
That's
you.
okay, no problem. But yeah, questions are fine. Again, if you have a question, raise your hand. Who's passing around the mic? Okay. Yep, the mic is here, so we got some questions, so go ahead.
It is, I don't have the exact date. I will know in probably April what the precise date is. It's always the first 2 weeks of the month. So it's going to be sometime in the first 2 weeks of May. But I'll be happy to tell everybody. And it's in Annapolis. It's called the Court of Appeals. It's 361 Row Boulevard. It's up on the 4th floor. And they start promptly at 10. It's fun. It's fun for me, but it's fun to watch too. And to be honest with you, having a group of people come walking in now, it's not going to influence the court in their decision necessarily, but to know that I'm not up there by myself and that there are people that I'm working on behalf of, the court will take notice of it.
Definitely.
Who hasn't seen Nancy in action, I saw her Supreme Court for Maryland, and I was just blown away. And also her opponent, the prosecutor's office, she went and shook his hand afterwards and said that was fun. And he went, yeah, right. Anyway, to me it looked like a slam dunk. But anyway, I have a question about the state. And like you're saying they're wrong, and that, I guess my question is about how strong their case is, or do they have, anything that could help their case? And also, do you have anybody or anything that really helps make your case so much stronger than theirs?
It's a good question, Pat. Yes, the state's argument, they are saying that the Adam Walsh Act, the federal SORNA Act, requires, absolutely mandates that states have a federal registry. That's just not true. If you read, don't bother because it's longer than you would ever care to read, but the act itself says that if a state's highest court finds their law, which is equivalent to the Adam Walsh Act, which is what Maryland has passed, the Maryland law on sexual offender registry is equivalent in a lot of respects, almost all respects, to the Adam Walsh Act. But it says in the Adam Walsh Act, if the state's highest court finds it to be unconstitutional, which is precisely what we have here, then what has to happen is the Attorney General from the state and Eric Holder need to get together and figure something out. That's literally what it says. And that's it. So they haven't done anything to figure it out, and it doesn't even say what they're supposed to do. It just says they need to consult with one another, okay? I guess to try and make it constitutional somehow, but there's no way you can make this constitutional because it's an ex post facto, and they've already called it punishment. So the state really, what they are relying on in the pleadings I've seen so far is a Fourth Circuit case from Virginia, which is not the equivalent because it involves a federal offense. Now, if you commit a federal offense, then the Adam Walsh Act does apply to you. But if you're purely a state offense, Adam Walsh doesn't apply unless you travel in interstate commerce. That's the only way they can get jurisdiction over the person. And so that's why I'm saying the state, in my opinion, really does not have a leg to stand on in this argument. And that's all they're relying on is that case.
I would add, if I'm remembering this correctly from Larry Neely, the paralegal that we work with, is that even in the federal case, even in the federal situation, there is no federal database that somebody can be on. So even though, and people who with a federal conviction are asked to register on the state's registry. So, eventually I imagine a case will have to, be heard to clarify. Somebody's going to call the question, but, but legally, they're obligated, a person with a federal conviction is obligated to register at the state, in the state they're in. So, that you go to the Drew Sogin or Sogin or however you pronounce the darn thing website, all that is a collection of state registries. There's no separate registry that's just for the feds. So, the argument I know that Larry's constantly making is, fine, you want somebody to be registered, you show me the registry and we'll put them on it. But the registry doesn't exist. So I think even in the case of federal, they're not going to have a whole lot, a leg to stand on. Just opinion.
And to be really honest with you, this getting too probably technical, but the Supreme Court has issued in the Obamacare decision, which you scratch your head, how does that relate? But believe it or not, the justices, the most conservative justices on the Supreme Court right now in the Obamacare, where they were ordering you as a mandate to get health care, some of the justices said the Congress can't do that. You can't order a state to institute these kinds of regulations or regulatory laws, and you can't order a state to punish someone for not doing it. So to me, that's analogous to this situation where you can't, Congress, if you want to say the federal law applies, cannot order states to adopt these kinds of regulations and then can't punish somebody if they don't do it. So we have a lot of good arguments, to be honest. Just even looking at the Adam Walsh Act alone, and then analogous situations from the Supreme Court cases, I think are all in our favor. I mean, imagine this Supreme Court, these justices saying, yeah, Congress can tell states what kind of criminal laws to pass. They hate that kind of stuff, these justices. They want the states to be able to have their own laws and do their own thing and not have to worry about what Congress tells them to do. So, I think even some of the more conservative justices are on our side on this issue.
Doesn't that kind of negate the notion of federal laws at all?
No. No, but when they're not every federal law, but when you are talking about crimes, it is quintessentially the state's obligation to deal with criminal laws, not Congress. So it's a federalism issue. It's do states have to do and pass laws that the Congress says they think are good laws? And the answer is no, they don't.
I have a roommate in Towson University and a family member that pleaded to a fourth-degree registration, non-registrational offense. And as of 2010, when they started the new law, they was forced to register because they were still on probation.
Right.
I'm just trying to figure out how do you go about that.
Yeah, well, that would be in the litigation that is pending now is sort of the same kind of situation where, because at a point in time, and I don't remember exactly when, but in Maryland there was a time when a fourth-degree sex offense, it was within the judge's discretion to order someone to register. So you could have said, no, you don't have to register. And now, as of 2010, they have to. So that falls into litigation that is pending in the appellate courts right now. So that person would be covered by whatever the outcome of these cases are. Which, by the way, through Brenda and Fair, I will keep everybody up to date regarding the outcome of those cases when they when the court decides. No, I'm sure he can't.
Nancy, I understand that you don't have a crystal ball, but say we do win with Doe, and say we do get a lot of people pulled off the registry. Is it going to be just a flip of the switch for the legislature to just go rewrite something and throw us back on?
No, because I can't, there's no way to rewrite an unconstitutional statute. And what's unconstitutional about it is making it retroactive, okay? Anybody who commits their offense after October 1, 2010, you have to register, and there's nothing we can do about that. And you have to register at whatever level, tier 1, 2, or 3. There's nothing really that I'm aware of can be done. But when they say that the law was unconstitutional because you made it retroactive, there's no way to rewrite that. You can't fix that.
Yeah.
So no.
Yeah, we would definitely need to be watching, because they will try to find ways they'll try to find.
Oh, they will, but I can't really even
but
fathom.
it would be difficult to really retroactively make things tough again.
Right.
Yeah.
Right, Nancy, I think that's one of the reasons why some of the states do not have a registry, or they claimed that it was unconstitutional.
Well, they all
so
have
they
a
didn't
registry.
follow the Adam Walsh Act as strictly as we are.
There are, I think it's 6 or maybe even more by now, 8 states that have done exactly like Doe, where their state court has said, under our Constitution, not the federal Constitution, we think it's unconstitutional, and we think it's punishment. So you can't make it retroactive. So Maryland, we joined those when Doe came out, those states.
There is I had my offense before the year 2000. I was put on probation in 2000, and that probation was over. I did the registry, so it's been a continuing punishment. It wasn't added on, it was just continuing. It's restrictive. It damages you in many different ways, and there are many others that I know that can relate to that. And you answered one of my questions, which was, I thought it sounded like it was automatic if you were a offender in a state that you're automatically federally registered, so it's not that. But the effects that this has on the business that you do, which is I operate a business, small business, it hasn't affected me that much, but I know it can really just shut people down, literally. I've had a couple of people that as soon as I give them an estimate on work that I'm doing, they'll get my card and they'll go right to the computer and Google it, and as soon as I see it, nothing.
Right.
So
I know.
In this man's case that he just mentioned, would it be inappropriate to use a pseudonym, an AKA?
In the class action, because it's a lot of people, we really couldn't say, John Doe 1. I mean, we could, I guess, but I don't know that the court would let that go forward.
Just for him, his customers.
Oh, I see. I'm sorry.
What if the conviction was, in the 80s, but in another state?
And you moved to Maryland, and in 2010 they made you register?
No, I moved to Maryland in 2005. 95. I moved to Maryland in 95, and 2001 they made me register.
Right.
A 10-year registration.
I think the same theory applies, that Doe, you are Doe.
Yeah.
Oh, I'm sorry. I think I can be a sympathetic member.
Okay.
And for general information, I have Italian background. In Italy, there is no such thing as registration. And I'm retired in the U.S., so I don't have to stay here, but I'm going to stay here until this case is resolved. And my sentence was passed from 10 years to lifetime.
Yeah. Good.
I was just wondering if there are any like big guns in this fight that are connected with the criminal justice system, that like people with lots of money, watched Warren Buffett the other night when show, and I was thinking while I was watching him, I wonder if there's somebody like him, somebody that cares about criminal justice that would be in this fight.
You know, I think that's a great idea, but if you can find someone, I asked a gentleman, an attorney who's very well known in the state who does class actions, if he would come and join me on this. And I have the utmost respect for him, or I would not have asked him. And he said, let me think about it. And he came back to me after 2 days and he said, you know, it's the group you're representing that I just can't do it. Yeah, I mean, and I hate to say that, but that's the hurdle that we have to overcome. And if you know, to be perfectly blunt with you, the reason I do this is because I just think the law is atrocious. I mean, and I think it's unconstitutional. And to me, not that it's not about the client, obviously it is. You are human beings, but it's just wrong. It's just wrong. I don't care who you are, and I don't care what group you are, and that's the way I think about law and criminal laws and cases. But not many do think that way, unfortunately. So if you know someone, a benefactor, someone that could sort of foot the bill, that thinks the same way, I'd love to hear from them. I'd accept anybody's help, to be honest with you.
My name is Sonia again, and so you did answer 2 of my questions so far. Is anybody else attached with you to help this cause? And why were you doing this was another question. And then my next question is, so a participant comes and wants to join your class action suit, and so they are a prime candidate. How long would it be before theoretically this person would ever, like it's 2014 in a couple months, when would you suggest they might even get off?
The class action lawsuits can take up to a year and a half, from when you actually file it. And there's a lot of legwork and just grunt work that has to take place before you even get to filing it. So you're in it for the long haul if you're going to be a plaintiff. It will, and again, it will be in the newspaper. That's the other thing. So that's why we need some real, strong-willed people that are willing to stay in it for the long haul. It will take, I have no doubt, at least 18 months after it's filed, once it's filed. I have a partner who thinks like I do, and she's going to do it with me. And I have a paralegal, and we have a law clerk.
Good. Yeah, and FAIR also has a paralegal who's going to be helping out. So we have another person there.
Yeah.
Nancy, well,
for the firm. Oh yeah, my firm's going to do it.
I know, but I would think it would be 5, 10.
I would love it to be. I would, but it is what it is,
I want to get a clarifying question on the timing. The year to 18 months, I assume, is to the first decision, and then again, if the state decided to appeal, we could again be going. Correct. Right. And the other thing I'd also want to try to clarify, the case that we're looking at the increase in term and possibly the increase in restrictions. Understand that at least our case, not these other ones that she talked about, but in our case, what we'd be looking at more likely would be take it back to what it was. So if you were originally off, then you might come off. If you were originally a 10-year, you'd go back to a 10-year. Okay, it wouldn't, the case that we're doing would be to roll things back to what they were on October 1st, 2010. That would, and maybe some before, depending on how the lawsuit works out.
It would take it back to what the law was at the time you committed the offense. That's what it is.
Yeah. So just understand that not all of the litigation that's happening, even with the best possible outcome, the end result is not necessarily a person's off the list. It will depend on, what the retroactive application was.
The offense or the sentencing?
The offense.
The offense.
That's critical. It's not the date you were convicted or sentenced, it's the date the offense occurred. So whatever the date is of the offense, that is, you look at the law as it existed at that moment, and that's the law that should apply to you. And so if at that time, this was not an offense for which you had to register, under this lawsuit, if we're successful, you come off the registry. If at that time it was an offense for which you only had to register for 10 years, then that would take it back to only 10 years on the registry. And for a lot of folks, that would mean coming off because they've been on for 10 years or more.
10 years is from your sentencing time, though, not the offense.
No, we're only looking at the, say it again.
I think I know what he's saying.
What are you saying?
Like I was convicted.
Yeah.
I got you.
In 2002, but in 2004.
Right.
Correct.
Yeah.
They said 10
Yeah,
years.
yeah, it
Gotcha.
would,
Yeah.
the registration would be from the
Period,
point
right.
that you began
From the date you were
registration.
sentenced.
Yeah,
Correct.
right. Well, hang on, we're going to get some questions in the back.
I think that you answered my question, but one thing I have to ask. Now, I was sentenced in '84. I was tried, found guilty. What good would this do for me?
The class action? Nothing, but Doe, if we win Doe in the Court of Appeals in May, you should come off the registry because you are Doe. And the state doesn't even argue, wouldn't even say Doe doesn't apply to you. Their argument for your situation would simply be the federal law requires you to register. And that's the issue that's going to be argued in May, so that if I win that issue, you come off the registry. It is good, right?
Is the federal law what they call a national registry?
That's what they're calling
Yeah,
it.
the federal law, they're equating that with the national
Right.
registry, which we are saying doesn't exist.
Saying that after 10 years.
Yeah.
they come off the national.
Remember, we've got people back here
Oh.
with the mic. So,
Mm-hmm.
there's some other folks in the back that,
Next question.
I might have missed this because I was out of the room for a minute, but so who is your state senator?
Jim Brochin.
I'm surprised.
I'm not.
I'm not.
My real question was, I'm concerned with education in a larger sense and presenting facts to people. I'm wondering, is it possible, but for someone, maybe me, but is it even possible for someone to tally up the amount of money that the state has spent or will spend defending this sort of thing and doing their thing? And also maybe other private individuals, that might be harder, but.
Mm-hmm. Well, I guess not really, because this is what I'm thinking is these are lawyers who are on staff, who this is their job day in and day out. So it's not like they're hiring a private law firm to come in and we're paying oodles of money for them to handle this or enforce these laws. So I'm not so sure that would be persuasive.
I just wanted to put a lot of people's mind at ease if they had any question as to the qualifications of Nancy, and if she's the right.
I don't think she meant that. I didn't take it that way.
No. But if she's the right person for this particular case, Nancy was formerly the chief
Public defender.
public defender for the state of Maryland. She left that, went into her own practice. She's one of an elite group of people that has actually won a very controversial case in the Court of Appeals. She is the only one, she is probably the most eminently qualified person to take subsequent cases like this to the Court of Appeals because she has already been there and won, and no one else has. So,
I know.
So let me put everyone's mind at ease and don't count the number of people that she has working with her, because she can do this by herself, although help is
very nice.
Help is encouraged. So thank you, Nancy, for all that you do.
Stuart.
I appreciate it.
Here's the thing to me is that that's most difficult. We're dealing with laws that make people unemployed, unemployable, and we're asking for money, to help us fight this. And so, but I understand that it's difficult for every one of you because of that. But that's the only way we're going to be able to get anything done. I don't charge a lot, but this is a huge undertaking, as you pointed out. So it really does require, if it's not you, it's your family members, it's somebody that hopefully can pony up and help us fight these laws. So, but I'll do everything I can. That's for certain.
It's definitely one of the things that I try to push as often as possible when I'm talking on the forums and when we call by phone, is that right now, for instance, our rolls, FAIR's rolls, we have a good 700 people on our rolls. So if you just think a minute, if the 700 people all contributed $100, just think how much further along we would be. And there are some of you, them, who have managed to do okay through they've managed to be self-employed or whatever. They could go ahead and chip in that $2,000 or $3,000 that they would have put towards a personal lawsuit, but this will do the same thing and it'll help everybody. So I try to mention that as often as possible, that there is strength in numbers. There's strength in, you don't need to be embarrassed if all you can send in is $40 for your annual membership fee, which also goes to the legal fund, by the way. But if you can contribute more, obviously, then that helps Nancy do her work. We might even be able to hire an extra paralegal or something. Yeah. But anyway.
Okay, next question. Yeah, my conviction, was a federal conviction, and so concerning, where they added time, I went from 10 years to 25 years, so if you were saying earlier, that this might affect, as far as the part of what you're doing may affect, to have the people who had time added, because under Maryland, I came under, category, what was that, level 4, category 4, the lowest one?
Right.
And they said it was still increased from 10 to 25 years. Mm-hmm. So, but because it was a federal conviction, I'm not sure what that would apply to me, because you mentioned, the federal statute. Mm-hmm. With which that would apply to me, correct?
I don't think that you could benefit. If it's a federal conviction, I don't think you could benefit from any of this, because there have been lots of cases at the federal level that have challenged SORNA, the Adam Walsh Act, as for being retroactively applied, and they've all lost. And there's a Supreme Court case right on point. So unfortunately, this could not assist someone who has a federal conviction.
Next question.
No.
Thank you. I got here late, so I'm a little at a disadvantage. But has there been any jurisdictions anywhere in the country, state or other, that have had any success in any of these aspects to get people, their registry changed in any cases that you're familiar with?
Well, like I had said earlier, that there are some states where, relying on their own state's constitution, they have said that it's unconstitutional to have retroactive laws. So they've held exactly what Doe has held. With regard to the scope of who it applies to, I know that there is only one state, and forgive me, but I can't remember which one it is right now, that has said that it only applies to those people who committed offenses before the actual registry came into being. So in other words, but that's only at a state, the lowest appeal level. That case just was decided a couple months ago. So I don't know if they're going to take...
Oklahoma, I think.
Oklahoma. Oklahoma. So this is sort of uncharted territory right now, as far as I'm aware.
Thank you so much for coming. Question, it's nuance. On the Doe case, if I remember the ruling, 3 judges, the plurality, they were the ones that mentioned shaming, public shaming, stocks. Mm-hmm. 2 said that the law had at some point crossed over to now it is punishment,
Correct.
implying sometime in the past it may not have been punishment. So my question, the nuance about shaming, and I'm thinking about people with convictions after 2010. If there's some nuance that public shaming, is that cruel and unusual punishment? Is there anything in the future that goes beyond what they found for Doe? Because that was a retroactive question.
Gotcha.
Is there something about public shaming
That's
that might not be constitutional?
That's a great question. And, you know, it's really hard to ever get the court to say that punishment is cruel and unusual. I mean, they don't even think the death penalty is cruel and unusual, but that would be an interesting litigation, to be honest with you. And, of course, that would require, again, another plaintiff but that's completely different from this, but I really like that idea, David. I think that's pretty good. Yeah. Right, because there were judges, the Court of Appeals are 7 judges, and one dissented completely, or, well, actually 2 dissented completely from the idea that this is punishment. But the plurality of the judges, because it didn't command a total majority, said that it is punishment. And 2 of those said it is only now punishment as of October 1, 2010, that's when it crossed the line. And it wasn't necessarily just because it's retroactive, but the intention is that when the law changed in 2010, they added all these new restrictions, the more time, everything. The suggestion is by those judges is that that's what took it over the line into punishment, so that even those who may have been convicted or your crimes occurred after October 2010 may now be able to argue, and again, it would have to be a separate lawsuit, that this is cruel and unusual punishment, all these restrictions. But I like that. I think that's clever.
I seem to remember from when I went to the national conventions a couple of years, and I missed this year, but in order for the states to get the federal funding from SORNA, they had to comply with everything. But that's changed now, right? They can pick and choose what they want to, which is why Maryland is not in jeopardy if they do go along with the Superior Court's or Court of Appeals ruling, that they're not going to lose their SORNA funding. They're still going to have that. That was my first question, but that is right.
The funding from the federal government is dependent upon whether or not you have substantially implemented SORNA. So it does not have to be identical, but it has to be substantially in compliance, and Maryland has been held to be substantially in compliance.
All right, so they're not going to lose a dime just because they
held it unconstitutional.
Exactly. All right.
Correct.
And secondly, right on the website, and every one of us has seen it when they go to their website and they look at their picture, it says on it that the use of this information is illegal for harassment, this, that, and the other. Yet people do it all the time. Every one of my competitors, I own my own business on the Eastern Shore, every one of my competitors has gone to every one of my clients for the past 7 years and flopped down the pictures that they copied off the internet and said, you know, you're doing business with it. Why are you doing business with it? I mean, and I've lost so many clients because of this. So they are harassing, they're using it, but what do you do? I mean, there's nothing you can do about it. Even the cops are using those pictures, to harass. So what do you do about it?
Now that would be a civil lawsuit you would have to bring against that person. That's the only. But they'll say it's not harassment, that they're just passing on information that's of public record. So you know, that's what they say.
If in the next few months the federal government defaults on their debts, would this affect their support of SORNA for the state of Maryland?
I don't know.
I doubt it.
I doubt it, but
I doubt it.
Well, as to your first question, I'll let Brenda answer the second one because I'm not really sure. But with regard to the punishment aspect, the court in Doe said it is punishment, and they pointed to vigilantism, shaming, and
restrictions. travel restrictions, for
Everything. I
instance.
mean, they lay it out there. They say this is just cross the line. This is punishment. This is no longer just a way to regulate the where sex offenders are. It is, and they talk a lot about what they consider to be punishment within the statute itself. So that's done. That the court even agrees with that. For Maryland. For Maryland's law.
Right. Each state would have to do that for its own law.
Correct.
Yeah, you can't take this decision and show it to Arkansas, and Arkansas would say, oops, So each state would have to do that individually. To the other question, putting on my other hat for a moment, I'm also executive director of the national organization. There is a legal group within RSOL that is keeping its eye out for cases across the line, and we're trying to develop, a group of folks like Nancy in each state, so they can at least talk to each other, have a data bank, have maybe eventually have funding, as you pointed out. We've pointed out people don't like to give money to sex offender causes. It's just an issue, but we are trying to develop that at the national level through our RSOL funding. Yeah.
Hi, Nancy. How come people, after your victory in March or May or whenever it was with Doe, how come we haven't fallen off, and I apologize if you've answered this question already, how come some of the members from the list have not come off?
Because the state is fighting it. The state is, as I said, and maybe you weren't here when I said it, is okay, that's all right. It took me everything I could to get Doe off, even after I won. Because the state thinks that you still have a federal obligation to register, and so they're not going to take anybody off unless a court orders them to do so. There is what's called a writ of mandamus, which is, I think I talked about this at one of our other meetings, which essentially would be, if I'm successful in that case in May and the state still won't take people off, then I would file this proceeding in the highest, back in the Court of Appeals, say, look, you've already ruled in our favor twice now, and the state still refuses to take people off. Order them to do it, and that the court would then sign an order that goes directly to the Department of Public Safety saying, take these people off who fall in that category.
Yeah, I know they tend to, well, what I've been told, not being a legal beagle, is that, the courts tend to not want to come back to an administrative body and tell them what to do. Mm-hmm. They sort of trust, I don't know if that's quite the right word, for say, okay, everybody, we said it's retroactive punishment, and then they toss it back to them to do that, right? But if they refuse to do what they should do, then the writ of mandamus
that doesn't make
in.
the court very happy.
No, they do not like to.
You ignore exactly what we've told you to do.
Yeah.
Yeah. Yes, and No, because the state has an argument that what they think is a legitimate argument to say we don't have to. But if they lose that argument, they have nothing else for which they can, lean on to say we don't have to do it.
Well, I mean, I haven't actually done an update in a while. I did, not too long after the big change in 2010, I did do a graph to show everybody how the different levels had shifted, and the drastic shift from the 10-year to show how many people were suddenly on it for a much longer span. We had a lot of people that went to life, but in 2009, actually, with the change of law then. But then the number who shifted to a Tier 3, which shows up, that's a huge flip-flop. I did do it then. I haven't gone back lately. I'm not sure if the 85% in Tier 3 is right. I haven't checked lately, but I would have thought more like 80, though. It's definitely close to around 80% of people. But it's been a while since I've updated that chart. Yeah, we'll do like one or two more. I think I said that one or two more ago.
Hey, in the off chance that we ever manage to get something like Doe to the U.S. to the federal Supreme Court, and they ruled in conjunction with the state Supreme Court, would that potentially be able to strike down everything across the board, the way across the country, the way the ruling about privacy laws in Texas did when
Yeah.
two gay men were arrested?
Lawrence v. Texas. It depends on what the issue is that goes before the Supreme Court. And the only way you can get in the Supreme Court is if it involves what's called a federal question, which means it must deal with either a federal law or the federal Constitution. And the only way I can see this making it to the U.S. Supreme Court is on the case I'm arguing in May, which deals with the federal law. Does the federal law require you at the state level, even though the state has said that it's unconstitutional, can you still be required to register? And if that goes to the Supreme Court and you win that, then that would affect the entire country, whatever the Supreme Court says.
What it would not necessarily do, it would be highly unlikely that any case is going to get to the Supreme Court that would, as people like to say, take down the registry.
Yeah, no, that won't
Okay,
happen.
because the registry is probably here to stay. What we can try to do is get it offline.
Yeah.
Okay, if all you had to do was go in once a year or send in your card or just keep your information updated so that they knew where you were. And it wasn't public, it wasn't, if it was back to law enforcement only, I think, it'd be a pain in the tush, but you wouldn't have nearly the problems that you have with it being public. I think we have a chance where that could, we could try to strive for that and to reduce the number of people on it, reduce the frequency of going in, making it less like you're getting booked 4 times a year. Those kinds of things is what we're probably looking at on the short haul and the longer haul. But the odds of, especially our current Supreme Court, making a decision that would drastically make a change, across the country, I wouldn't hold your breath on that anytime soon. So, I hate to do the bad news kind of thing, but just realistically, we're looking at, smaller steps, not major steps.